9, 12, 10, 28, 2, 23.
This is the DSR Podcast. Hello and welcome to a special issue of DSR in which we talk about the recent Supreme Court decisions, the conclusions of this term of the Supreme Court. And of course, we turn to our favorite and the best Supreme Court whisperer, analyst out there, Dahlia Lithwick. She of the Amicus podcast and of great columns at Slate and of great books and many other things, who has a little bit of sniffles today. Are you doing okay, Dahlia?
Yeah, just asthma. I think I'm allergic to authoritarianism, David. I think it's just a persistent.
Who knew?
Sorry about the sniffles. It is not my cocaine habit. Sorry.
Oh, well, that's a relief. All of us were worried about a relapse. And of course, so we've got you here today because I really want to know what you think of the Bezos wedding.
Yeah. I mean, I'm sure you saw, and it's a subject for another day, but an hour before we started taping, the Supreme Court just granted cert on like striking down what's left of campaign finance. Like they're going to get rid of the last vestigial bit of it. So, we need to be very nice to Bezos is what I'm saying.
Well, let's roll back the tape. And what I'd like to do, and we can end with talking about what's coming in the year ahead and possibly over the summer, because they're those scallywags at the Supreme Court now. They do all sorts of unplanned, unexpected things. But it was just a week ago when you posted a podcast talking about the worst Supreme Court decision of the second term of the Trump administration, which was probably not overtaken as the worst decision for several days. But let's start with that one. And for those of you who don't know, you should be listening to Dahlia's podcast and reading what she writes. That was the decision taken sort of off schedule to say the Trump administration can go ahead and rendition people anywhere they want in the world until we finally decide this, whenever that may be, and do so without due process and, have at it, boys. And they did this decision, interestingly enough, without any explanation. And so the place I'd like to start is your reaction to that.
Well, I actually think I'm very happy you're starting there because I actually think that makes a really nice rhyming couplet with what then happens on Friday in the birthright citizenship, because they're two sort of flavors of the same poison ice cream, which is kicking the knees out from under the federal judiciary, right? And so I think that, the reason we were horrified, and I might actually maintain that decision, because it happened on the shadow docket, there was no analysis. We actually don't have any idea what the basis of that decision was. Might still be worse than birthright citizenship, but I think it's the package it comes in, right? The fact that the court makes a decision with no holding that any judge can follow. And immediately when the lower court judge in that case was like, well, I don't know what this means. This is why the shadow docket is a problem, right? So the very quick and dirty version, David, is exactly what you just said, that the new Trump policy is if we have permission to deport someone anywhere, we can deport them anywhere, including places like Sudan, places where there are no Americans allowed to be there. It's so dangerous. And so this is an American policy under Trump that just says, if you are eligible to be deported, we can send you wherever we want in the world, to whatever nation we have a side deal with, who will just warehouse you in a prison. And by the way, there's almost no due process. And so this goes to a judge called Brian Murphy, who issues not one, but two restraining orders saying you can't do this. They need a certain amount of process. And the court kneecaps them, as you say, on the shadow docket. We don't know why. There's no analysis. It's just a decision by the court that says, no, you can go ahead. And so it's a horrifying decision, both because, tens and thousands of people are now going to be eligible to be deported to, torture prisons. And it's in violation of, a statute that prevents torture. But it's also because the court did it on the emergency docket without telling us why. And so if the original sin is that the court's one job is show your work, they don't show their work. They just kneecapped a judge. And that becomes, I think, the only context in which you can look at the birthright citizenship case, which is in which every judge gets kneecapped now.
Well, there's several levels of perversity to this decision, right? And doing it on the shadow docket with no explanation is certainly one, because the court has become less transparent, even as it's become more apparently corrupt and more apparently political. And so that's obviously very, very troubling. But I think another, dimension of this is that there is a pattern now of the court saying, you see this case where the final decision, when it ultimately gets adjudicated, is pretty clear. We're going to punt that into the indefinite future and let the Trump do whatever he wants for some period of time, do huge amounts of damage. And we'll come back to this in terms of these other cases. But it goes back to, the cases against Trump and not hearing them for a while and finally reaching a decision when it was, so close to the election that it was clear that if he won, he was never going to be held accountable for anything. And so they're kind of doing his heavy lifting here with this policy of punt and permit.
That's a really good insight. We had been complaining for years that justice was too slow, right? That it couldn't keep up with all those Trump trials, that there was no way, whether it was the Mueller report or whether it was Jack Smith, like nothing could ever happen fast enough to actually act as a check on him. And you're exactly right. We now have the prime mover in that dynamic is John Roberts' 6th Justice majority on the Supreme Court, who are slow walking. You have district court judges again. We have Judge Boasberg, right out the chute, who was trying to prevent those planes from taking off to El Salvador. The administration, in blatant violation of that, says, make us, right? We have, and again, Judge Murphy last week in this third country renditions case, where again, you have district court judges doing the thing that they do, right? Which is, I'm scrambling, I'm having a hearing really fast, we're finding testimony, we're creating a record, I'm enjoining this while we figure out what's going on. Justice Sotomayor in her dissent in that shadow docket case, basically accuses the majority of making it impossible for judges to do the things that judges need to do in order to check Trump. And you're right about two other things, and I think it's really important. One is it comes under this posture of, look, this is really complicated. We'll be the deciders, right? That's essentially Brett Kavanaugh's completely incoherent concurrence in the case about birthright citizenship. Don't worry, we'll get to all of this. In fact, we'll get to it on the emergency docket with no reasoning, but we'll get there. But it really does, I think, sort of cut out the very heart of what the Article 3 judiciary is supposed to be doing, right? District court judges are supposed to hear cases and decide issues of fact. And when someone is breaking the law, at least theoretically, they're supposed to enjoin them until we know what's going on. And here's the court saying, oh, no, with really intemperate language, by the way, about district court judges, saying, no, you just sit there and look pretty and we'll decide every single thing eventually when it comes to us. And then I think the other thing that you're saying that is so important, and it's really, I think, the heart of the dissents by Justice Sotomayor and Jackson in the birthright case, is that you have to be a special kind of clueless to not see this in the context in which it is happening, which is that Trump breaks the law and the courts stop him. And then the Supreme Court says, go ahead and break the law again. There's no other way to see this. And so to do an academic exercise like Justice Barrett, who's like, oh, let me put on my CivPro hat and tell you about, courts of chancery in the 1700s, and there's no analog for nationwide injunctions. I mean, you have to be a special kind of stupid not to understand the context in which this is happening, especially when, this is where you started, in the very same week, this administration did the same thing on the shadow docket to a district court judge.
Well, there is, stupid is part of it. I think there is malevolence part of it. I think there's a clear political agenda that's part of it. And one of the things that's happened here, and we'll get to the other cases in a moment, but you're so on the money on all of this, is that the court seems to be at war with all the other federal courts. And I saw a Substack from somebody who may be very distinguished, who I don't know who it is, named Adam Bonica. And I don't know if you saw this, but the Substack says it's called "The Supreme Court is at War with Its Own Judiciary." And the point that it made is that since just this spring, 94% of district court decisions have gone against Trump. And the exact same number, 15 out of 16, Supreme Court decisions have gone in his favor. In other words, you would think if the law was the guideline, there might be some dispute over some things. But essentially, the Supreme Court is in the position of taking very clear-cut cases that all judges, Trump judges, Bush judges, Obama judges, seem to be reaching, and they're going in a different direction. And there can be no other interpretation than that they have a political agenda. Maybe I'm overstating it. That's how it looks to me.
No, and the cherry on top really is that you can say, as a neutral academic matter, David, there's a problem with nationwide injunctions, right? There was a problem when it was President Biden's, student debt relief plan, enjoined by a single judge. There was a problem when Matthew Kacsmaryk in Texas, right, enjoined the use of mifepristone across the whole country. So we can have an academic debate about the wisdom and utility of a single judge in a single district being able to enjoin a policy nationwide. And that, by the way, has been raging for a long time. But when the Biden administration went to the Roberts court and said, you know what, let's think about this question of nationwide injunctions, the court didn't want to take it. Not interested, didn't take it. Now they take it on birthright citizenship. So any attempt to construct this as a sort of set of neutral guiding legal principles about, the powers of the separate branches or the sort of, excessive powers of a single judge in a single district is the lie is that this is the first time this has come to the court. It's not. It comes to the court 5 months into the Trump administration when 24 plus different judges have enjoined, cuts to foreign aid, cuts to hospitals and schools, impoundment, all of it. The one thing, as you say, judges across the ideological spectrum can say is this is illegal. And this is when the Supreme Court says, oh, this is an exigent emergency. There's one other fold to this that we should raise, which is, Professor Steve Vladeck, who's written so, beautifully about the shadow docket, the emergency docket, keeps making the point that you have to ask yourself when you get these cases that haven't been briefed, they haven't gone percolated through the courts, right? There's no arguments. There's just a back of the napkin, we don't actually know if it was 5-4 or 6-3 because we don't even know who signed it, much less there's no reasoning. And the problem with that is that the court starts doing what it calls equity, right? Which is we're just going to do a little justice here. We're just going to make things right. And what you get is the court deciding for itself. And I think this is your original point. And it's so cynical that the exigent emergency it has to contend with is not that in half the states at the end of 30 days, whenever this off-ramp is, there's going to be children born who are stateless who are literally stateless, that's not the emergency. The emergency is all these runaway, renegade, ideological district court judges who are stopping Donald Trump from doing what he wants. And when the court determines that that's the emergency, and not only is it an emergency, but they're not even going to get to the birthright citizenship question, there's not even going to be a hint of what that decision is on the merits. Ask yourself, again, it gives away the game. The court says the emergency in case after case after case. And this is the same emergency we saw, by the way, that the court resolved on the merits docket in immunity last year. The real problem is chilling Donald Trump. That's the problem. That is the thing the court has to get involved with. And that's insane when you think about people being sent off to Sudan to be tortured.
Yeah. There's one other issue. And I seem to keep coming up with one other issue to keep us from getting to the birthright citizenship case. But the one other issue is Trump and his DOJ have thumbed their nose at the courts throughout this, and the court rewarded them for it. The message of the court was, go ahead, go ahead. We've got your back here, buddy. Now let's turn the page and let's then go on to 5 days later, 6 days later, and the so-called birthright citizenship case, which essentially didn't address that, even though, and I'd love you to address this in your response, even though it is such a matter of clear law, the language of the 14th Amendment is so clear on this that the court could very easily have said, look, folks, we don't have to go through this for a year, right? This is obvious. And because of the administrative burdens and everything else and the confusion, we're going to resolve it right now. But they didn't do that. Instead, they said, no more nationwide injunctions. If you want to, look out for a group of people larger than a single plaintiff, you have to do a class action, which is very complicated. And I might add, either option where you have to go to court to defend your rights is not an available option to most people in the United States because you don't have the lawyers, you don't have the money, and so forth. So this is saying we're only going to be concerned with the rights of those with the wherewithal to go to the court. And so, they go to this and they say, just work your way through the system. The Solicitor General used the term percolate. And there are 94 federal district courts, I think, something like that. That's a lot of fucking percolating to get to, a just outcome, particularly if the question could be one, as you say, that somebody in one state could be a citizen and not in another state. They could be eligible for a passport in one state and not in another state. They could be eligible to be deported in one state and not in another state. And that we're not going to address this for years. And this goes again to this point I made about punting, that essentially what they're saying here is we are giving the President of the United States 1, 2, 3, 4 years of freedom to do whatever he wants before we're going to get to it, which is, it's kind of like, Trump said he'd be a dictator on day one. They're kind of like saying, you can be a dictator for 3 or 4 years. That's okay. We'll get around to it after that.
Right. And that is, I think, the substance of Justice Sotomayor's dissent, is that what you are saying is that the president can go around, the next president, assume a Democrat, can go around and take guns from everybody, and we'll just wait for the system, right, to work it out, for it to percolate. And
somehow I don't think it's going to work out that way.
No,
right?
It's not going to work out that way. We know that the minute a Democrat is in office, the nationwide injunction will suddenly be, urgently necessary to the Roberts Six. A couple of things that you're saying are really important. One is, and again, it goes back to what I said about how you cannot look at this without the context of, this is the Trump administration that has been going after law firms, right, that attempt to aid people who resist Trump and Trumpism, right? I mean, shuttering their ability to give the kind of services that the court blithely is like, oh, go find a lawyer. You'll be able to do this as a 23B class action. Yeah, but they're shutting down law firms that are trying to help the resistance. That's one thing. Two, this is the court that for 15 years now has been making class actions harder and harder and harder, right? So they're saying, look, there's this avenue. It's called the class action. Go ahead and do that. This is the same court that has cynically, right, made class actions harder and harder and harder in terms of class certification and what you can bring. And again, looking at the context, this is the court that is saying, oh, don't worry, honey, just go ahead, find the filing fees, hire an attorney. There's no harm, no foul. This is simple, simple, simple to people who are going to be very unlikely. I think this is implicit in your question, to be like, look at me. I'm possibly having a baby, imminently, and it may or may not be a citizen. Who wants to be a plaintiff in that lawsuit, right? So every level of this.
But also, I just have to interject. If you're poor, you don't even know this is an option. If you're poor, you can't afford a lawyer. This is saying that that there are classes in our society, and one class of people will have access to justice, and another class of people won't. And above all that will be somebody who is not accountable to justice, the President of the United States.
Right. And the language that's used in the dissent is this law-free zone, right? That the president can go ahead and operate in a world without law for as long as he wants. And here's, you and I had this conversation after Dobbs, when there was this checkerboard system, of like, now abortion is not legal in these states and it's legal in these states. What's the object of having a really lengthy period of uncertainty? The point is, A, terrorize and chill people from seeking services, right? B, have people self-deport because they're afraid. C, have people, not stand up and assert their rights because they're afraid. I mean, this goes to your point about why you drag this out for a very long time, this uncertainty, maybe in New Jersey, not in Pennsylvania. I don't know. Do I have to cross the border to give birth? Does New Jersey have standing now to bring a lawsuit and claim that the state is harmed? We don't know. We're just going to wait now, as you say, possibly for years, because let's be clear, John Sauer, who argued this case for the Trump administration, was like, yeah, we don't really think we have to follow district court orders, and we're not super sure we're going to follow orders from the appeals court. We'll probably follow a Supreme Court order. So what you're going to get is they may lose and lose and lose and never appeal, right? And then this goes on even longer. And who is served by having massive chaos and uncertainty and a patchwork of different laws in different states? The people who want to terrorize the most vulnerable citizens. And the one other thing I want to say, and I don't know if I'm right about this, but I remember you and I talking about how Trump keeps doing these as executive orders, right? This is not an act of Congress. This is not a law. I have been joking for 5 months that an executive order is in effect a letter to Santa. This is what I want to see happen. It has no force of law. But what the Supreme Court does when they say you go ahead with your executive order, now it does have the force of law, right? Now all of his agencies are going to fan out and figure out a way to take away birthright citizenship in the states that don't fight this. And so you've actually just turned a crazy piece of, stroke of the pen fiat by the president into the law. And that might be the scariest part of this that I think hasn't surfaced yet.
Yeah, I agree with you. Because I think the implication of that is, and take everything back into the Trump case and through this, that that as a matter of this Supreme Court's view of the law, we presume that the president is right, and we presume the president has the power to do what he's doing. And there was language, incredibly naive language about that in the Barrett decision, essentially, the president will, we assume the president will do the right thing on this kind of thing, which is just insane. I would add one other thing before I move to the other case, and that is, there is a non-legal context of this. There is the administrative and the congressional and the budgetary context. And if this bill passes the Senate and the House, and they give ICE a budget that is the equivalent, greater actually than the budget of the United States Marine Corps, ICE is going to be able to violate the law at industrial scale, with industrial speed. And so all of a sudden, you're going to have many, many more violations and many, many more cases that are going to have to percolate their way through this system. And the more clogged up the system gets, the slower the process gets, the more off in the distant future justice gets. Now, another problem was manifest in the case that, again, misleadingly may be referred to in some headlines as a Planned Parenthood case. But what it really is a case about the degree to which citizens can use civil rights laws to protect themselves and get what they deserve from the government. And the court, even as it's taken away, given the president a lot of powers, taken away some others, is in this case, it seems to be stripping away a pretty important right from average citizens. Is that your read on why that's an important case?
I think it's a singularly important case, and I hope, it contra your Substack from this morning, that everything disappears, you blink, and we don't have a fulsome airing of what it was. I hope that as the summer goes on, we can really talk about why I think it's an incredibly important case. But you're absolutely right. The gist is you had a statutory entitlement to the physician of your choosing, right? Even if you're on Medicaid. And that's codified in a statute. It's clear what the intent was. And we have South Carolina that wants to defund Planned Parenthood. Planned Parenthood can't give abortions, right? We've got the Hyde Amendment. We've got a million constraints on Planned Parenthood. What it does is all sorts of, STD checks and mammograms and other essential services. But many, many states hate Planned Parenthood. Why? Because Planned Parenthood, in theory, somewhere is still providing abortions. And so the decision is taken that we're going to, preclude people from seeking services there. And you're exactly right. There is a statutory entitlement to that. It is not in question. And the court goes ahead and says, yeah, no, that's fine. And so every other state that now wants to defund Planned Parenthood will be able to do so, has a green light to do so. And it is such, again, a willful misreading of, a directive that was supposed to give patients, particularly poor patients, the right to have a physician of their choice. And a very cynical reading, but I think it's of a piece. And you're exactly right that what we get in the dissent is this has a long story to history, in civil rights law. This is part of a way of thinking about how helping people effectuate their own rights. And it's gone with the stroke of a pen. And I think, your larger point about both these cases is that it's just not just, as you wrote today, death by 1,000 little cuts, but death by 1,000 arcane legal abstractions, David. Nobody is waking up the next day screaming about this case because it seems really, really technical. And, I don't fully understand, what it matters. If you can't get your health care at one place, you'll go somewhere else. But, and again, under the looming shadow of massive healthcare cuts. But I think it goes to your larger point about all of these things. I remember this time last year, we were talking about Chevron deference and trying to get people to be, 5-alarm fire about what it means to strip agencies of regulatory authority. It's so cunningly done in this way of a million abstract arcane legal principles that it's really hard to get people to see what it is that the court is doing, that they're choking off just fundamental, in this case, statutory entitlements. And it's a bunch of legal jargon and, shruggy emojis. And so I don't know how we get folks to focus on, the thing that you're describing and I'm describing, which is every day, thanks to the John Roberts court, the water's a little dirtier and people are a little less healthy, and, more dark money floods into the system and it's harder to vote. Like every one of those things happens every term. And the response is, I'm sure you get the same mail I do. Well, I don't know what to do about it. Like the court's the court.
Well, and that's the problem, and I do think there, it has stuck in my craw as I have looked back to the first year of the Biden administration, where he said, I'm going to have a blue ribbon commission to look at what to do about the court. And it was complete bullshit. They didn't care about it. He didn't do anything about it. And the reality is this: if this court is allowed to do what it's doing, and you talked about granting cert on, campaign finance, and that goes back, to their greatest hits album with Citizens United and the whole fallacy and pernicious fallacy that money is speech, right? That people can go out and rich people should have greater power in our democracy. But they're going to go down this road as far as they can, and that's not the only case they're going to carve away rights. Just what we've seen this year and what we saw last year, and maybe next it'll be Obergefell and the right to people to marry who they want, or it'll be some other fundamental right. And they punted on a gerrymandering case, and maybe next year they'll get around back to that, and that the only way to stop this is to structurally change the court. Because with a 6-person majority, it is the only way. You have to have whatever is 13 justices to correspond to the number of the federal circuits out there. However you do it, adding states, something has got to be done. Term limits, something has got to be done to change this court, or the court is going to be the engine of the destruction of our democracy. It's not going to be any one person.
Well, I think we're in a foot race now where we have an imperial court that created an imperial presidency that is now being bolstered by an imperial court. So, I think you're exactly right to say they are working in lockstep, and they are working to systematically carve out of any kind of structural checking system, not just Congress, which is supine, but the federal courts, right? I think that's the takeaway. That's where we started, is they are both working together. And remember the language from last year in the immunity decision, the just dripping contempt for, federal investigators, right? These awful, awful people who could indict a ham sandwich. And the dripping contempt we get from this court about, EPA regulators, right? Or people who work on vaccines and diseases. I mean, this has been a slow march from the Roberts, 6 to both dismantle, regulatory power. I mean, we haven't even talked about, all the ways in Humphrey's executor is over, all the ways in which independent agencies have been imperiled this term, but to sort of slowly dismantle regulation, slowly dismantle any sort of check on government, and now to go after judges, right? Lower court judges. And I think we just have to see it as part of a progression to say there's going to be 2 winners, and it's either the Supreme Court, not all the Article 3 courts, the Supreme Court, or it's going to be Trump. And I think you and I probably slightly naively believed, because there was some signaling around the Alien Enemies Act when the court was pushing back initially on the shadow docket and saying, hey, if you're going to rendition people to El Salvador, they need a little due process. It looked as though the court wanted to be the decider. And I think that we have to put that to rest. I think the court is no longer super worried about checking Donald Trump. And somebody posted on Blue Sky, and I don't remember who it was, that I can't determine anymore, David, whether it's more depressing that they just don't know how dangerous this is, or they don't care. That the 6 justices in the majority are just completely blinkered to what it is that Donald Trump has done and is continuing to do, or if they know and they're fine with it. And I think we're going to now live in the sort of detritus of John Roberts, the great moderate, and Amy Coney Barrett, who had a moment there, when she was supposed to be the big, woke liberal, and Brett Kavanaugh, I guess. And we're going to watch them try to make sense of whether they really, truly want to give, Donald Trump, like, the loaded gun on the table to do what he wants to do. But it sure feels like when I read Barrett's opinion and I read Kavanaugh's concurrence, I don't see any impulse to shore up checks and balances. I see an impulse to shore up the court itself. That's it. I think that's the only interest that remains for them.
Yeah, I think they're playing the role of criminal defense attorney that's trying to make their clients' crimes look better. And that they are trying to, dress it up. John Roberts likes things to look a certain way. He doesn't like, ugly criticisms of the courts and so forth. But, behind the scenes, what they're doing is dismantling. And although, I wrote about, this is slow enough that most people don't, scream bloody murder with each particular case. Citizens United was 15 years ago. This has all happened in 15 years. In the context of 250 years of American history, that's real freaking fast, right? 1776, or, the Battle of Lexington and Concord in 1775 to the Constitution in 1789 was the same period of time. And here we are watching this get undone, right? And it's deeply disturbing, and I do think it is going to require that people who are actually concerned about it to start thinking, I can't win this case in this system. I need to change the system.
I think going back to your, Substack, I think, we always say this, you and I, but like, we have to think in terms of structures. This is not like, oh, Skirmetti was a bad decision for gender affirming care. Like, we have to think about systems and structures. And as you said, we have to think about reform, and that requires like sustained, focused attention on abstract ideas. And that's really hard. I think I sort of do want to point out that what we're seeing in the No Kings marches and what we're seeing in the Elon Musk and the Tesla protest, I think puts the lie to the idea that Americans don't care about democracy. I mean, we've heard pundits and pollsters tell us for quite some time that Americans don't care about a malapportioned Senate. They don't care about the filibuster. This stuff is like way, 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 way too inside baseball. They don't care. I think they knew that Elon Musk, nobody elected that guy. I think they knew what it meant to have, mass firings without any like recognition of merit and who was doing good work. I think that in a deep sense, Americans understand that the court is letting them down. They've understood that since Dobbs. And so I think now is my joke is always when people are like, oh, we need structural court reform. I was like, right after you buy me the DeLorean, right? To go back in time and do it in Biden's first, year. I think that this is a really good teachable moment. And I also think, and this is really like the stuff that, the Tim Snyders and the Jason Stanleys and the, Ruth Ben-Ghiats tell us over and over again, which is now's a really good time to go down to your local courthouse and put your skin in the game. And when there are ICE raids, you sit there and you bear witness. Like, I think that this is a very good moment to realize that, like, justice is not a thing that happens for the last 2 weeks of June out of the Supreme Court. Justice is a thing that happens down the road when somebody is summoned into court and then arrested by ICE for doing nothing other than showing up to court. And I think we can physicalize that and embody that in a way that might be really important, even if you're right that we can't pay sustained attention. We're in a news blender, it's hard. But I think some of this stuff is resonant, David, and I think understanding that like we are all only as free as the guy who's a US citizen who just got grabbed by ICE. I think people understand that, and I think that we need to have like meaningful political leadership telling us where to go and what to do about that.
I totally agree. And I think that we all have a role to play in this. It's not just up to whomever the next president of the United States is. And I do think there are a lot of tools to do it. And I do think there's momentum to do it. And I do think, as I also indicated in my last two substecks, that I do think generational change can help us. Because I think there's a lot of energy in a younger generation that's just disgusted by this also. So we will keep talking about it so long as they allow us to have open conversations about this in the future. And anytime I get a chance to talk to you, I learn, and we all learn, and we are deeply, deeply grateful. For now, thank you, Dahlia. Thank you, everybody, for listening. If you like this kind of thing, go to the dsrnetwork.com, click on membership, and help support us so that we can go on having conversations just like this one. Until then, bye-bye.